This is Bernard Wolfsdorf. I am an immigration lawyer here in Los Angeles. We welcome you all today to the fourth in our EB-5 webinar series. This particular program today will focus on regional center setup, and most importantly, we'll focus on the distinction between the so-called direct EB-5 program, now called more commonly the standalone EB-5 program. I will go through the basics of advantages and disadvantages of the direct versus the regional center program. We are very fortunate to have live here with me today Michael Gibson, the Managing Director of usadvisors.org. Michael is, in my opinion, the go-to person when it comes to evaluating financial risk. I do not think there is anyone today in the EB-5 arena with the knowledge and depth and dedication of Michael Gibson. His background and training is very, very extensive, but most importantly, he's dived into the EB-5 arena and without a doubt, in my opinion, is the most knowledgeable person in terms of evaluating risk. We are also very fortunate to have with us Jor Law. Jor is a business and securities attorney, and I've asked Jor to focus on the key elements of structure, that is how to set up the direct EB-5, what the structure looks like, and how to set up the regional centers and the specific projects, what sort of structure will work from a corporate framework. And this is what Jor does. He is a business and securities attorney. He can help with PPMs, private placement memorandum. He can help with setting up the corporation, and most importantly, he can help with focusing on the structures. Our fourth speaker, Brian Sue, is traveling today, so we do not have Brian on this particular series. By the way, you can use your chat column and ask questions. So we will be collecting questions at the end, and we will be available to answer all of your questions today. So to those of you who are relatively new in this program, by the way, the Part 1, Part 2, and Part 3 of this four-part series is available on our website. If you go to wolfsdorf.com/free webinar, and you will see the prior three are all recorded, and you can listen to them at your leisure. So those are all available and online. Again, basic bottom line with regard to this EB-5 program. This program was established in 1990 by President Bush Sr. with the Immigration Act of 1990. This is not a new program. This is a 23-year-old program. Also, while I am just killing a little bit of time because I see a lot of people signing on at this point, just to bring you aware of our EB-5 and webinar series. Today, of course, is the EB-5 $501 million. On February the 6th, that is tomorrow, we will have a workshop on visa options for graduating students. That was a very, very popular topic, which we will be doing February 6th. On February 13, we will have another webinar for religious worker visas, ordained and non-ordained. That is done by Cliff Rosenthal, probably one of the leading authorities in this arena. February 21, we have another one focusing on Immigration 101 for human resources. March 21, we redo the student webinar. In April, we have another corporate webinar. We're going to be focusing on E-Verify and other important topics. So let's get moving here, and let's get moving on our topics. I'm going to, the way the program for today is, I'm going to fly through the basics. because they are pretty general, but for those of you who are not that familiar, we're going to focus on the difference between standalone investor EB-5s and the regional center EB-5s. We're going to talk, of course, about financial risk management, which is why we have Michael Gibson here, and we're going to talk about structure, which is Jor Law's specialty, and then we'll have a Q&A at the end to get all of your questions answered as much as we possibly can within this framework. Again, very simply, the program works as follows: invest $500,000 or $1 million, depending on geographic location. If you're in a high unemployment area or rural area, it's reduced down to $500,000. High unemployment, 150% of the national average. Investment must create full-time jobs for 10 U.S. workers. People keep forgetting this. This is a job creation program that's full-time, 35 hours a week. The green card is issued on a conditional basis. Yes, that's what a green card looks like. It expires in 2 years, and then the person has to apply to remove the conditional nature of the green card. So in a standalone or direct, the investor will buy a business, start a new business, inject capital, which is more complicated. If it's an existing business, must create 10 direct employees. There must be a nexus between the cash investment and the job creation. Very few applications, although we are seeing a turnaround in a big pickup, particularly in the franchise arena. So what is a regional area, center? This is a designation that, quite frankly, isn't as important as people may realize as to particular area, particular subset of types of investments that may be permissible. Up to now, about 90 to 95% of applications have been within the regional center, but that's going to drop, in my opinion. We currently have 251 regional centers. Of course, we have to look at the specific projects. Now, there's one simple advantage of regional centers: indirect employment counts. This is critical. If you're putting $500,000 into a project and you have to create 10 full-time jobs, just do the math on this, folks. I mean, even at minimum wage, it's costing you $300,000 a year. You know, this is a big headache for a lot of people, and they don't quite get it. 10 full-time jobs for a period of 2.5, 3 years. That business better be making money, or you're going to be paying something like $1 million just to maintain that kind of payroll. And that's what has driven the regional center program, because it will permit indirect jobs, indirect and induced jobs. Okay, so those are the basic facts. Standalone versus regional. I'm going to fly through these slides because this is an advanced program. You're all pretty much familiar with this. When do we do the standalone or direct? This is for the person who really wants to start or manage their own business. In a nutshell, people forget this. We have this big swing back to standalone and direct, but they don't realize these individuals actually have to manage the business. They have to be in the location, and many of the investors, as we well know, about 80% coming from China, you know, they don't necessarily want to live in Alabama where that new store is set up and run the business. It's a question of, do they have to be in the physical location? This standalone works where the investment is the driving force. The individual really wants to try and make some money. Michael Gibson will talk later about actually getting a return, but this is for the person who really wants to maximize their profits and is ready to be hands-on in terms of day-to-day management of the business. The regional center, of course, works for retirees, people, just the reverse factor, where immigration is the driving force, and they really just want a green card, and yes, they are effectively buying a green card. What's wrong with that? You know, people get green cards through the lottery. Is it appropriate for someone who invests $1 million and creates 10 jobs to get a green card? Well, that's not my opinion. Congress has already decided it is, and the program is very popular with strong bipartisan support from both the Republicans and the Democrats, and we do actually anticipate seeing revisions to the program in the President's immigration reform package, which pundits are saying will probably get pushed through Congress by August of this year. So Going for the basics again, trying to fly through these slides. What's the requirement? I-526 petition for direct or standalone. Proof investment of capital, prove that it's a TEA, targeted employment area. You need a TEA designation in order to in order to lower the amount from $1 million to $500,000. The person has to have invested or actively be in the process of investing. That's deceptive because, quite frankly, you really need to have pretty much your money all invested. The comprehensive business plan, absolutely critical, required by the regulations, matter of how, that's H-O. You need to read that, matter of how, if you're going to be involved to understand what has to be in a business plan. Proof of full-time direct employees. You know, I tell all my clients, register for E-Verify. That is the program that will certify that you have legal workers in the United States. Now, you know, if it's a troubled business, you can show that you've maintained the jobs, but you have to show that you've maintained all of the jobs, which is quite a challenge. Troubled business is one that's lost 20% in the last year or 2 years prior to the filing. So jobs must be created within 2 years, actually 2.6 years, 2.5 years, 2.5 years, you get 6 months credit because that's how long apparently it takes to process a green card, which is quite frankly not true. On that little point, by the way, 526 petitions taking 10 months to adjudicate. Yes, folks, March 16, 2012 is the current processing date for 526 immigrant visa petitions. So it's not like these people are going to get green cards in 3 months. The reality is that the processing time, close to a year just to get the petition, and another 6 to 8 months to adjust status or process, close to 2-year processing, with the potential for the Chinese wait line to improve. This is going to jump to 2, 3, 4-year wait for many Chinese applicants probably later in the year as the visa quota backlogs. Engaged in the business, this is the critical problem with standalones. The individual has to be engaged. I'm not going to get into any depth on purchasing an existing business, but just people should know that the restructuring or reorganization when you purchase an existing business in the standalone or direct is a complex situation. The government is quite restrictive. If you look at the case of matter of Sofici, where somebody redid Howard Johnson's, anybody would think this was a restructure or reorganization. It didn't quite work that way, and the case was rejected. Bottom line is they really want to see an additional 10 employees, a clean additional employees as a result of restructuring and reorganization, unless it's a troubled business. Source of funds, very important. They want to make sure it's clean money. Path of funds, they want to make sure it's not commingled with dirty money. And those are 2-hour topics that we're going to slide through. Adjudication of the 526, already spoke about that. Backlog till March 16, 2012. What's happening to premium processing? Nothing. It's not even on the horizon. In fact, my information about the 526 program, the EB-5 program currently centered at the California Service Center, is that even though they've made an announcement to move it to Washington, they haven't really started. They haven't even really started hiring. Nothing's happening. You know, this thing's going to take 6 to 12 months. It's going to be a bit of a mess for the next year or so. But our Director Mayorkas, Immigration Director Mayorkas, very dedicated man, has made this decision. What if you denied your 526? Yes, you can appeal to the AAO. The statistics are the government wins 99% of the time. You can also file a motion to reopen. Unfortunately, there are denials coming right now. Denial rates are probably going to climb over 10, 15%. We're hearing them. Of course, the story in the EB-5 arena, nobody has any denials. Every regional center claims to have no denials, except we keep hearing about them from the clients. And of course, I can claim we have no denials, but, and it's true actually, but it's not over till it's over. Regionals, and when I say not over till it's over, what I'm talking about is you've got the 829 stage, which is the critical point, judgment day. 2 years down the road, you have to file a petition to remove the conditional nature of your green card. So choosing a regional center, we're going into regional centers. You've got to look at the project. You've got to look at investor information. Due diligence is the magic word. That's Michael Gibson's business. And what are the distinguishing characteristics of this regional center? What are the track record? I'm going to fly through this very quickly. Project pre-approval. Technically, you can file an exemplar, get an approval. What does it mean? Not too much, apparently. It should mean more, but that's the simple story. What are the distinguishing characteristics of a regional center? You have private or governmental. There are, in fact, government projects. I'm not sure that they're any better than some of the private projects, but that's not my area. Debt or equity, is it the loan model or the equity model? The loan model is majorly in favor right now. How many 526, 829 approvals do they have? Is the money in escrow? What's the exit strategy? How do you get your money back? When do you get your money back? And, of course, financial security and rate of return. And, by the way, any guaranteed rate of return will cause the program to be denied. So anytime somebody guarantees you a 10% return and all your money back, run the other way. That project's going to get denied. Did I just give financial advice, Michael Gibson, that I shouldn't have given? Lawyers keep saying, oh, we don't give financial advice, and then, of course, we do give financial advice. We have to be very careful because, unlike Michael Gibson, I do not have appropriate registration to give financial advice. So moving forward, there we go. You've had enough of Bernie Wolfsdorf so far. This is Bernard Wolfsdorf speaking here in, I normally say sunny Los Angeles. The sun is maybe coming out. And we have Michael Gibson, who's sitting downstairs, and he is seriously the guy to go to, the source for information on the U.S. EB-5 program. Michael, very, very experienced in strategies for selecting EB-5 projects. I get this call every day, so tell me which project should I invest in, and I just say, sorry, not my department, usadvisors.org, EB-5 info, Google eb5info.com. His website is knockout good, okay? I wish I could say the same about my own website. It is not knockout good, but it's going to be improved when we get the time, but Michael Gibson's is the absolute source. So, Michael, let's talk about this. What are the two principal risks that are going to be involved? I'm not even going to stick with the slides today as much. I really ask you to talk about what are the risk factors when it comes to evaluating a direct or standalone program, either an individual business or a franchise versus the regional center framework. Where are we with this? What do you tell clients? How do you operate? Take it away, Mike.
Okay, Bernie, first of all, thank you so much for inviting me to participate in this panel again and for inviting me to Santa Monica. I thought it would be nice and sunny, as all the commercials are about California, but it's a foggy day, but I'm happy to be here, so thank you again. I want to touch on and this is, by the way, a very timely topic to be discussing, because we are seeing a shift in our clients coming to us and asking for more information on direct investments. And I think you touched on it a bit earlier. The reasons they're doing it is that we are starting to see more denials, more project failures, and more concern among investors that all is not clear and sunny skies with the EB-5 program. In fact, many of these projects we're starting to see are running into difficulty both to create the jobs or, and this is the important thing to know about the program, create it in accordance with how the business plan was laid out and with the current market conditions. So we're seeing large pools of limited partners investing in projects that are claiming when the I-29s are going to be filed that they will be 50, 60, 70% occupied with tenants. They will be generating all this revenue, which leads to the expenditure methodology, which then creates all of these both direct, indirect, and induced jobs. And in fact, what we're seeing is that because of either project delays, insufficient capital, delays in obtaining their certificate of occupancy, whatever the reason, we are starting to see that the I-29s are being filed, and they are the project itself does not have sufficient tenant occupancy. They're not fully occupied, or they may just not even be in the process of actually in operation. So the limited partners in these pools, which we're seeing today in the market, are extremely concerned, and they should be, because not only is the risk of the I-29 not being approved a very real one, but I think material consideration would be they may not actually create sufficient value in the asset to be able to get their principal investment back to refile should the I-29 be denied. So the concern in the industry that we see from the attorneys who represent these investors and from the investors is that they have lost control of their future, if you will. So what we are seeing is a move or a shift to people wanting to recoup that control, and the key factor that they're looking for in the selection of a direct or standalone investment versus a limited partnership or indirect passive investment is they want to have a greater degree of predictability in the investment. So what I mean by that is that if they do their own investment, they invest $500,000 or $1 million, and they purchase a franchise or they build a business, their future is in their hands. They control the outcome. They control, even if they hire a management company, and they are somewhat limited in the active part. They participate, but they're maybe not day to day. But they control the number of people that are being hired. They control the expenses, the burn rate. You know, how much money they're spending to generate the revenue, and ultimately they control the creation of value, which is the slide we have here. So in this respect, we see a lot more interest now. Although it is more difficult, the 526 application that you and your attorneys will file will be more complex, because you don't just get the package from the regional center. You have to provide the business plan. You have to create a number of other documents and the impact analysis. So that for the attorney who's filing, it is a more complex process. However, the clients, the investor clients, are choosing this more and more because of the predictability to control their destiny.
Mike, thank you. I totally get that, and I see a huge shift right now with investors being, quite frankly, very, very concerned. Mike, I know you've touched on this, but talk to me a little bit about the kind of research and review and the due diligence that you provide that help potential investors make the decision.
Right, great. Well, this is what we counsel everybody, whether they use our firm or another financial analysis firm. All that we do is really, we are just trying to determine probabilities of success. I think one of the earlier slides was pointing, there's two conditions that we need to hopefully achieve through this process. The first one is the approval of the I-29, so that the investors get their conditions removed on their residency. So the green card, the green card without conditions is the primary motivation for everybody who is coming in. So what we try to do on that to determine the probability, what we'd like to see is how probable is it that that project will create sufficient jobs to satisfy the removal of conditions, not only for your client, but for all of the clients in the limited partnership. And I think this is important because of the large delay times, we are seeing that, as I believe is happening, when one I-526 is filed, I think over in Laguna Niguel, they're waiting until a substantial portion of the limited partners file, let's say 2 to 3 months. So they may have all of the LP 526s in a hopper, if you will, waiting to see, did this project actually accomplish the goals as laid out in the business plan? And for a number of reasons, and I'll give you 3 that we see quite often, which would result in a denial. the most common one we see is insufficient capital to complete either the construction or maintain the operation. So I've seen 5 in the last 3 months, 5 projects, which have not been able to raise the capital required to complete the construction, or even in some cases begin the. We've seen projects where there have been over 40 I-526s filed, and they have not even begun construction. So the capital is a huge concern for many of these projects. The other one.
Can I jump in there and be rude? So there's sort of some basic words of wisdom. You don't want to be the first investor and the last investor. That would seem to tie into the concept you just made. Can you elaborate on that comment?
We actually don't even think it matters anymore, because in these projects, you have to, whether you're the first, the middle, or the last, you have to ask yourself, or whoever's guiding you on this, once the capital is raised, will they be able to complete the project on time? And as I've said before, I think that there's more focus now on, once the asset is created, once they achieve their, they get their certificate of occupancy, they open their doors, and they begin operation, how fast will it take them for them to ramp up and achieve those job estimations that they had submitted in the original 526. And the problem that we're seeing, and this is largely in part driven because of the Chinese influence on the market, the Chinese agents don't like the smaller projects. For them, it's a big problem to train their sales force to do a $5 or $10 or $20 million raise. They prefer to do the $50 million, $100 million raises because they get larger commissions, it's easier for them, and they can spend the time to ramp it up. The problem is, to raise $50 or $100 million, even in China, is quite difficult. So you may have projects that are not able to begin for 6 months or a year, and then with a large project of that size, you're looking at typically 18 months, 24 months time construction. So you're not even, the doors are not even open by the time you should be filing the 829. I think this is problematic, because at that point, if you've submitted a 526 and said, okay, we're going to have so many tenants, or we're going to be a hotel, and we're going to be having certain ADRs, and you're not actually open or in operation, or you have not achieved stability to support those conclusions, I think these investors are going to have a lot of problems, trying to get those conditions removed.
Mike, that's really handy advice, and I'm seeing that as well. As I'm seeing projects getting bigger and bigger, 200 million, 300 million. I mean, just gigantic projects with huge amounts, huge numbers of investors. Now, I just want to turn to a specific subset issue, and that is escrow. Now, escrow is not required, but of course it's common, and I'm sure this is something that you recommend. And I have 1 or 2 projects I'm working on right now where they're really in a hurry to try and get the approvals, get the cases filed, because once they have received, say, 25 approvals, at that point that will be the trigger to release a certain amount of money from the escrow that they can then use to move forward on the project. What are you seeing in that arena? And Jor, I know you're on as well. This is your arena as well, so feel free to jump in. What do you from a risk perspective, Mike, what do you recommend in terms of escrow, when the money is released, what percentage of approvals one would need? And Jor, you're the guy who actually sets this up. Any tips in terms of how do we protect the investor in terms of getting the money released from escrow? Michael, do you have any comments on that?
Yeah, Bernie, that is such a great point. I'm so glad that you brought it up. It is a huge factor, and we have seen in the last 6 months a number of centers and projects that used to have full escrow, meaning they waited until the 526 was approved until they released the funds, to a partial escrow, meaning they would withhold 25, 50, 75%, and then do a partial release, to now where they're not even waiting. They're just saying, there is no escrow. And the problem is there's 2 competing forces here. From an immigration standpoint, you don't want to wait. You want all of the money raised to go into the project as soon as possible, so that you can begin the construction, complete it, get into operation, and hire all those people that you said you would be doing. That's on the immigration side, one competing force. The problem is on the other side, if you are fully invested in a project and they are not able to complete the capital raise, or any number of other problems come up, and they cannot file either the 526 or the 829 will be denied for who knows how many reasons, your investor will not be able to get their money back because there is no, the money's not in escrow. So for the clients who like the safety of having it until the 526 is approved, and then they can say, okay, well, this project is going to go forward because it's not going to be rejected by USCIS. For them, it's a big problem if they are fully invested and the 526 is denied. What do they do? And I don't know if there's a good solution to this.
Joel, what do you recommend? You're the guy who sets these up and drafts these escrow agreements. Any words of wisdom, sir?
Yeah, I think it really depends on what side you're on. You know, if you're an investor, you know, clearly having the funds escrowed until your approval goes through is in your interest. You know, maybe that's offset a little bit, you know, if you really believe in a project and if you thought that if the project had your funds, you know, a little bit earlier, that might, you know, do something for you. But if you're an investor, clearly the longer things are in escrow, the better it is for you, so long as it's still compliant with, you know, USCIS and EB-5 requirements. If you're at a company, you know, I actually think it's risky to take the money unless you're very sure that you could pay it back if something goes wrong. What I'm nervous about are the, you know, some of our clients do this. There's an increasing trend toward not escrowing or having a quasi-escrow where the money comes out when the I-526 is filed. And for some of our clients, that doesn't matter because we've done business with them, we know them, and we know that there's a wealth of reserves, you know, behind them or a parent company that can honor that obligation. But I have to say that sometimes I look at these deals and I'm not so sure that the issuer will have money to return to an investor if there is for some reason a denial that's not the fault of the investor.
Very helpful. And, you know, folks, people need to know no matter how much the agent or the marketing individual will tell you, you know, money back guarantee, wonderful, you're going to get all your money back. The whole essential element of these regional centers are risk. It's all about risk. Your money has to be at risk, and there's no question that you can lose a percentage of your money. You can lose all of your money. You can lose your administrative fee. So these are many of the problems and snags that one has, and due diligence is just the name of the game here. Perhaps more important than anything in terms of evaluating. And let's switch over right now. We've kind of touched on this concept of fair value, so I'll move forward. You know, what do we look at in terms of the project, the value at its inception? Gosh, I can't talk today. The projected fair market value at the term, the exit, the source of the capital, management experience, prior existing litigation, are there cases going on at the moment, the need for the product. Mike, these seem to me to be basic, logical criteria that one would use, quite frankly, on any investment project. How does this differ if you're looking at a direct or standalone project versus a regional center project? These are, I would say, you know, great 12 critical points to take into account. Is there a difference, perhaps to put better, is there a difference between the way you evaluate a direct and standalone versus, you know, a regional center project, and understanding there's certainly a difference between the mega projects and the smaller projects, but just generally speaking, direct versus indirect?
Right, and what I would say to that, Bernie, is actually we don't really, most of my analysts don't even know what EB-5 is, and we don't really, the visa component for our analysis is really not that essential. All of our analysts are either credit analysts or equity analysts. we look at this as a private equity offering, and we use the same credit analysis techniques and equity that Wall Street uses, with the exception that we do have to hire economists to evaluate the impact analysis. But that's a completely separate discussion. When we're looking at fair value, which is what we're speaking about here, whether it's a regional center investment or it's a direct standalone, the analysis is exactly the same, because what we're trying to determine is the future value of what is that asset. And I think this is what is lost on a lot of people who are counseling their clients, and I'm speaking to the attorneys out there, is that they're not looking at a real-world scenario involving the probable exit of these assets. What they're being told is that their clients are going to get their money back, or maybe a payment in kind, another asset in return for their $500,000. But when you look at that industry, or you look at that market, for instance, if they're building a shopping center or a hotel or assisted living facility, and you look at markets currently, at assets in that market, and the exit, what they entered in at, comparable assets, you don't see anywhere near the fair value. And what I mean by that is, if you raise, say, $30 or $40, $50 million for a 100-room hotel or a 100-room assisted living facility, and the asset sales for those assisted living in that market or hotels in the market is $5 million, then there's obviously a disconnect. So from an EB-5 perspective, we don't accept, as I say, except for the impact analysis, which is done separately. When we're looking at value, we don't really care about EB-5. We just do standard credit and equity analysis.
Mike, you make it so clear, and I just, this has been obfuscated. Gosh, I can't pronounce today. This has really become murky. People don't get it. The lawyers don't get it. Generally, the truth is, lawyers are not business people, and we kind of get confused. And I know even myself, I didn't get this barrier, but at this point in my career, 23 years later, I filed my first EB-5 case in 1993, a troubled business. I love bragging about it. I got the approval in 24 hours on an expedite for a troubled business. 24 hours later, boy, that's the good old days. That's like when I was young. Coca-Cola cost 5 cents, right? 5 pennies, and when I was young, boy, that was a long time ago. The program today is massively complicated, and Mike very, very kindly just distinguished between the two critical elements. The first being immigration risk, which is something that I can do as an immigration lawyer, where I'm looking at things like the job count cushion. Is there 3 to 1? If we have to prove 10 jobs per individual, direct or indirect, do we have, in fact, 30 jobs available for each individual, or do we have a 1.1 count? If we have a 1.1 count and there are delays or occupancy is much lower than was projected, we're going to have some problems at the 829 stage. So what kind of cushion do we have on the job count? What is the realistic projection in terms of this business? Obviously, the two are tied together. If the business is financially not successful, vacancy rates are sitting at 90%, where we projected they would be 10%. That is obviously going to impact to some considerable degree the number of jobs that are created indirectly. The other thing that we look from an immigration risk perspective are things like tenant occupancy, which is the government's big bugaboo. They still, in my opinion, haven't quite got it worked out. We've had some guidance memos. The first one wasn't helpful. The last one was helpful. But these are still, let's call it treacherous areas where the shopping center, for example, is counting the jobs that are created by the tenants. And that is something the government generally does not like, unless, of course, the capital is going. The government has a very simple position. You investing $500,000, great. You investing $1 million, excellent. Question, how is that investment, what is the nexus between that investment in the commercial enterprise and the job creation? Now that has to be direct, that has to be clear, that has to be simple. If you try and obfuscate, there you are, I got the word right. If you try to obfuscate the connection between the investment and the actual job creation, whether direct or indirect, you're going to lose. This is what the government wants to see. This is a job creation program. I don't think the government wants to give you a green card because you put $500,000 in a business. They're going to give you a green card because you created those jobs. And that's where we're having the big problems today. So government logically wants to see it. So we've got the immigration risk factors, which is my job, Bernie Wolfsdorf's job. And then we've got the financial risk factors, which is Mike Gibson's job. You know, the two work hand in hand. I don't do his job. I'm pleased to hear he doesn't do my job, or I'd probably be unemployed because he's so much smarter than me. But, you know, we work together as a team, and we get the job done. You know, after I've spoken with Mike, I often feel nervous. He does make me nervous. It's good to be nervous in this program, quite frankly, because, you know, you really only need 2 or 3 clients to lose their $500,000, $1 million bucks to find yourself in a very frustrating situation. You know, 99% success could mean you have that one case that went down with a lawsuit, and that is no fun. I have no idea why this thing is just jumping forward. It seems to have a mind of its own. My PowerPoint has been possessed by, what can we say, elves, little green elves that just keeps moving forward and backwards. Gosh, that's kind of crazy stuff. Here's some ideas. Mike, I passed on the slide. Do we have any comments of what we don't look at, what's not relevant to you in evaluating an EB-5 project?
Right. And I would say, Bernie, on that, anything that can't be supported by independent verification. So the first thing we see in all the marketing material are claims being made by the issuer or the developer or even the state or the EDC. And the claims are fine. It's okay to make a claim, but if it can't be independently verified by a third party, then we don't really take it into consideration. And I think the big problem in our industry is that there is very little transparency and clarity as to what is actually being done. The one area that we focus on the most in the business plans and in the offering documents are the sources and uses of funds. And I think in this case, you're going to learn a lot about what are the intentions of the developers versus what they're claiming in the marketing material, because as Jor will tell us, is that they cannot or they should not make material misrepresentations. Now, they don't usually speak about, for instance, I think we talked about this the other time, we will see developers who are inflating the value of their assets or their position or their equity position in these projects, and that will be contained in the sources and uses of funds. And there's a lot of information in the offering documents which is not in the marketing material, but if you, as the attorney or the advisor, cannot independently verify the claims being made, then they should just be discarded. That's our underlying assessment.
It makes so much sense. It's logical, but you know, we don't stop and think about it. EB-5 is no different from any other arena, but it's emotional. The simple bottom line is every one of my clients, and you've got to be an immigrant. This, by the way, is my phony South African accent, phony British accent. But you know, for immigrants, this whole big thing of transition, most people just don't get it. Is a hugely emotional, moving to America, living the American dream, educating your kids in America. It's a huge big thing, and people obfuscate, my favorite word today, the critical element that this is just a regular old investment. And then I get it 3 or 4 years down the road where people are like, oh gosh, you know, when do I get my money back? How do I get my money back? How much money do I get back? Suddenly becomes the major thing after the person's got their green card. So, you know, what do? We call Michael Gibson, Michael at US Advisors, 239-465-4160. Call, I'd love to say call 1-800-239, but, you know, it just, wow, it really works. 239-465-4160. There's Michael Gibson. he is the guru of this business. He's the guy I go to when people ask me, so which regional center should I choose? You know, we're not allowed to say that. We don't make recommendations. We cannot make recommendations. You want somebody who's really kicked the tires, looked around, and made sure that they have evaluated this in a very deep financial perspective analysis. We are now moving over to, let's call it last but not least, Mr. Jor Law. Comparison of possible regional center roles in EB-5 transactions. Whoa, what's happened there? Seriously, my PowerPoint is possessed. Some of these, like jumping, is my fault, but a lot of it is little green elves who've possessed my my PowerPoint and just keep fast forwarding it. There we are, the disclaimer. We've got to do that. This is not legal advice. This is not accounting advice. These are not professional services. You can't sue me because of something we said here today. Why do lawyers do this all the time? I don't know. You know, it's called CYA. You know, we need to put that up in the front of every PowerPoint because, you know, this is also recorded. So those of you who've missed it, you know, you can leisurely Sunday afternoon, instead of reading a newspaper, download this, forward it to your friends. All of it is there, but of course, remember, it's not legal advice. It's not accounting advice. Gosh, you know, may be accurate, may not. You need to call an attorney. You need to call a advisor, and you need to call a specialist. So what I asked Jor to deal with today really is, you know, structures. I want to know about structures because I get this all the time. It's like, you know, I have this business, and, you know, this guy wants to invest $1 million in my business, and yeah, you know, 10 jobs, no problem. You know, how does this work? You know, that's where I just say, look, do me a favor. That's not my deal. I know a little bit about that, but we really want to work with somebody who does this as a living. And so, Joel, you're in charge. Take it away. What do you tell folks?
Sorry.
I want to invest $1 million in my sister's business, and you know, I want to get a green card, and I'm transferring the money tomorrow. So will the green card be ready next week? And what are you going to do for me?
Yeah, Bernie, the title was my mix-up, actually, not your mix-up. So let's just go ahead and jump to the next slide. So a lot of the things that have been talked about already are covered on this slide. You know, the differences between direct EB-5 and regional centers. The next one, Bernie. So really, this chart, what this chart really kind of does is summarize a little bit of the things that, you know, Bernie's already talked about. You know, just to let you know, regional center deals may typically be larger because of, the higher job counts that are available. The cost to document those deals are typically a little bit higher. For example, you have economic reports that you don't have for direct EB-5, and you may end up having different entities and a larger transaction structure in regional center. Direct EB-5 is an equity model. Regional centers are typically debt models. We can go into what that means a little bit later. And these are some of the differences between the direct EB-5 and regional centers from a practical perspective. Next slide. So this slide doesn't say very much other than to point out how much more complicated a regional center offering might be. On the left-hand side, you see the documents that are typically seen in a direct EB-5 offering, and then you see asterisks next to a couple of these items because depending on how you do it, you might be able to skip these. It's not recommended that you do, but sometimes, law and paying lawyers is not the goal of life, so, sometimes you cut corners and you say, okay, I'm going to take the business risk of not doing this. And so long as you understand what those risks are, in direct EB-5, sometimes these documents are skipped.
Joel, let me butt in. Just running through this list here, what do you do? I just want to understand who does what, because this is sort of, the immigration lawyers, the sort of quarterback overall. We have the financial advisor, but let's just go down this list of regional center business plans. You don't do that. Business plan for project, economic report. but it looks to me like you pretty much do all the others, right?
We do everything else other than the immigration aspects, which we didn't put in on here. Obviously, the immigration is your quarterback, and the I-924 filings, the 526 filings, all these coming up with a structure that is going to get approved by USCIS and be EB-5 compliant. That's a huge element. That's not on this slide because I was focusing more on the documents that we need from a corporate perspective. But from a corporate perspective, we handle pretty much all of these except for the first row.
Well, let's move over now to the, seriously, I'm having a problem with my, there we go, my slide advancement. And Jor, you've given us some pretty helpful and useful drawings right here. Jor, explain this to me. What is this?
Got it. So we're going to go through a series of models. They're going to be a little bit complicated, and and we're not going to cover each slide in detail because that would take too long. So if any of you guys have any questions, give Bernie, Michael, or I a call. The three of us should be able to explain what the model looks like in any of these. And if there's an answer one of us doesn't know, well, I'm sure the other one does, and we'll be able to refer it over. So this first slide covers what is a typically thought of as a direct EB-5 model. And I realize my slide is wrong here because the word regional center should not apply there. Should not be in the middle of the slide. It should just be that one entity, that single entity in the middle should be the capital raising entity and also the project company. That means that you've got one company going out to raise the money, and that same company is then taking the money and using it, much as if you were going to start a business yourself. You would put money into the business, and that business would just then go and hire jobs, hire people, and conduct business.
So this is another word I could probably use for this is a pooled investment. We've got 8 people technically putting money into the capital raising entity and project company. So we could get 8 friends together, each put $1 million in. We got an $8 million raise, and then the question is, how is that entity going to go out and create 80 direct jobs? Is that the correct frame here?
That's right. And then, the key thing to note here is that this is one of the simplest models because this isn't much different from any other business going out and raising pooled funds from anyone else. Google at one point did this, Apple at one point did this, Facebook at one point did something like this, except for they didn't use EB-5. So the key factors here to realize is that it's one entity, and then also because it is only one entity, that your investors are tied in with that entity. So your investors are your co-partners, your co-owners in some fat manner, and they have a direct connection to the assets. And they have some say in control. Even if they have minority control, even if their rights are limited, they're still entitled to some basic rights as co-owners. And this is really the direct EB-5 model.
So again, I'm going to take the rap for this. I was nagging Jor, and he got my slides in. You do need to delete the word regional center up there. Let's just call it a typo. Delete the word regional center. What that really should be is the individual entity. And I see you've got the LLC or LP or Corp. Does it make any difference to you, Jor, whether it's an LLC or an LP or a Corp? Do you have any preference?
For direct EB-5, and Bernie, you're going to kill me because what happened is I deleted the word regional center on this slide and not on the next slide, which deals with the regional centers and not this one. So that was a big goof on my end. For direct EB-5 model, I don't care as much typically because on a smaller offering, a lot of times the investors are known to the company. A lot of times it's a more intimate and more negotiated deal, and the idea of putting them into a corp and giving them some sort of day-to-day control, isn't necessarily opposed by the company. But for a company that wanted an investor and really wanted the investor to be silent, it's probably better if it's LP, just because there's a statutory exclusion or exemption from the day-to-day management. But for direct EB-5, we see a ton of corps actually.
I noticed that, and people were worried about this requirement that you manage, and I think it's being skipped over, and I don't think I almost see a big problem emerging. There's this huge big shift towards direct or standalone, and there's this requirement that the investor has to be involved in the management. Now, if you have a limited partnership, and the Uniform Limited Partnership Act allows you to limit the role of that partner, then you can always say, well, I'm in compliance with the Limited Partnership Act, and therefore I cannot do more. But, with all this direct investment and these folks realistically, a lot of them simply not being engaged in, day-to-day management, we see more LLCs going in. Perhaps we can restrict the role of that minority shareholder through the operating agreement, but, I think some of this is untested right now. And I'm sure, Jor, you're addressing these issues when you advise folks on direct. I'm a little worried about this issue because at the end of the day, all of this evolved out of the E2 investor program, and I can tell you that the E2 investor, that's the non-immigrant visa program, is absolutely required to, quote, direct and control the commercial enterprise. So there's this big focus in immigration law about investors directing and controlling the commercial enterprise in the non-immigrant scene. And, this has been addressed in the regional center concept. Legally, the limited partnership is a way to minimize the involvement. Many of the investors do not want to be involved in the day-to-day operations of the business. Many of them are not qualified to be involved in the day-to-day operations of the business. And I think this is a new arena which creates some concern because it is unfortunately a legal requirement. Jor, I really do want to spend time understanding these various structures, and even though my last-minute push caused a typo there, again, remove the word regional center from this slide. Whoa, what did I just do? Okay. Don't trust me with technology, by the way, folks. The most simple advance, forward, backwards, of course, I'm not getting it right. So what do we have up here? You've got, this is your direct equity single entity model. Hey, what's different? That's the slide?
Well, it's roughly the same. Of course, I blew and I took out the name regional center up on the first line. But it's essentially the same model when it's a direct EB-5 versus a regional center, and it's a direct equity single entity model. The only difference really in this case is that you can count the indirect and induced jobs. So for all other corporate perspectives, the same risk issues, the same risk and everything apply between this slide and the one right before it. You don't see too many regional center deals that are structured that way, but there are some that are like that.
Tell me about this next slide. Now, we've got indirect equity single entity model. By the way, we're going to have a test at the end of this for all of you to make sure that you can tell the difference. Stop that, Bernie. Jor, what is this thing here?
So nothing has really changed out of here, and we call it a single entity model, although we've now taken the regional center out of the center entity and moved it to its own. But the actual capital raise itself is really still in one entity where the entity is raising the money and then going out and using that money itself. It just happens that the regional center, separately sponsors the project. And the reason why this might be done is that the regional center may not be affiliated with the capital raising entity or the project company. It may be someone who has a regional center that they're loaning out or leasing out to someone with a project, or it may just be that the regional center has other ideas and wants to sponsor multiple projects and not lump them all in.
This is, Jor, just to put it in simple terms, out of the 252 regional centers we have operating, I don't know, probably, no more than 25, 30 of them are active with active projects at this time, but this is the basic model, right? This is what we're seeing right now. This is 80, 90% of the regional centers have this basic framework. Is that correct? Of the active ones I'm talking about.
No, it'll be the next slide because this one doesn't contemplate the drop down of a loan. So it'd be the next slide. But this is the core structure that 80 to 90% of the deals are structured upon, except for many of them will just add on one more entity.
Well, thank you. And I just fast forwarded to that next one. So here we have indirect equity or loan model, two-entity model, regional center, putting it into the capital raising entity that in fact makes the loan to or invests in the project company that's actually hiring the workers. So you've got to show that nexus between the money being raised from the investor through to the project company and the job creation. That is the most important thing. Elaborate, Jor. How does this work?
So this is exactly like the slide before, except for one key difference. Instead of the entity that raises the money, taking that money and using it for itself, that entity now is taking that money and loaning it to or investing into a project company. The slide says usually LLC. That's because we see that in EB-5 a lot. But it could be any sort of company at that point. The reason why we see LLCs more commonly, I think, is that EB-5 tends to center around real estate. Most people use LLCs to hold real estate. But that could be a corp, that could be any business entity. It really doesn't matter from an EB-5 perspective at that point. So the key difference here is this is what most people call the loan model, and the loan model dominates the EB-5 arena at the moment. But it could easily, just as easily, not be a loan model. The key feature here that differentiates from the other structures is that the entity that raises the money doesn't use the money itself. It loans it out to another company that uses the money.
And of course, some of these structures can get a whole lot more complicated, but you don't want that. You want this as simple as possible. When I put these cases together, I try to say to myself, make this simple. The examiner needs to understand how this all works. You can use your charts, but you've got to make this very, very simple. And the government wants to see that that money that the investor is putting in is directly linked to that job creation, and that you're not taking a situation where the shopping center is already being built and you've got bridge loans, and you suddenly heard about EB-5, and you want to pay off these bridge loans, and the job's already there. That kind of thing isn't going to work. You really want to set this up correctly from the beginning so that the immigration examiner can make a direct connection between the investment and that job creation. That is the critical nexus that will result in a successful EB-5 program. By the way, and now you talk about the loan model being the standard, that wasn't always the case. Going back a couple of years, there was talk that the equity model was the only viable model. Now it seems to be that the equity or loan models are acceptable, with the loan model being preferred. And I understand mainly because there's a perception that with the loan model, it's easier to get your money out than an equity model. Although I'm not quite sure how true that is in real life, nor would I opine on that. So let's jump over to the next slide if you're ready. Regional center sponsorship role. What does this one say?
Yeah, before we get into that, I'll tell you a quick story about the loan model versus equity model. When we first got into the space, just a few years ago in 2009, when most people started getting into the regional center aspect of the space, Bernie was in before that in EB-5. But when we first got into the space, it was definitely dominated by equity model. There was a large deal that we worked on that for a particular business reason, they couldn't structure it as equity. Their other equity partners just would not accept another equity participant in the deal. So we had to figure out a way to structure it as a loan. And at that time, China being the hottest market then already, what the agents were refused to do a loan model, and said that they wanted equity. They thought equity was safer. They needed to know they had equity so that it was safe. And it took us, I don't know why it took us so long, but back and forth, over the course of a few months, we convinced them and educated them on U.S. law and explained to them that technically a loan, an investor holding a secured loan interest would be infinitely more secure than someone having an equity position, which would be the last to get paid out. So, I don't know if it was and they bought it, they ran out, and then soon after that, we started seeing a lot of deals in the marketplace request a loan model. So I don't know if our firm had anything to do with it, but if we did, I regret that, because I think there are a lot of uses for EB-5 as equity that, get overlooked.
I was going to compliment you, but it turns out I have to blame you for that. Take the credit, Joy. The loan model seems to be kind of attractive, but it's interesting as to the complexity. So explain the slide to me again. We use so many acronyms here, but turn this into English for me.
Yeah, so these next 3 slides that deal with RC role, they only apply to regional centers. And it's really to highlight, sometimes people wonder, like, well, why should I do a regional center when I don't need it? And the regional center gives you a little bit more flexibility, but sometimes people don't realize that if they get into the regional center business, they may be able to leverage other uses of the regional center. So these next slides kind of talk about how regional centers play a role in servicing other people's deals, that are not their own deals. This first slide talks about sponsorship only. This is essentially where a developer or an issuer or some company goes to a regional center and says, hey, I'm in your territory, I'm in your industry codes, I need to count indirect and induced jobs. Can you sponsor my deal for me? So the regional center says, hey, okay, we will. We'll take care of filing to USCIS and taking care of the reporting and doing what we need to do as a regional center so that you can count indirect and induced jobs. But other than that, we're not doing anything else. Pay us our fee. Thank you. Goodbye. And that's one role where the regional center just does that. And in essence, they're providing a service for a fee. Much as maybe you would go and hire someone and say, hey, can I put your name on this deal and say, I'm Better Business Bureau accredited, or I fall under your, program. In this case, it's just a regional center. So that's what this slide talks about.
This is the so-called rent-a-center, and I guess can make sense if regional centers know what they're doing. They set up to manage this. They have experience in it, as opposed to the developer suddenly going into the regional center business. But the downside, of course, is they're going to have to pay a cost. They're going to have to pay a commission. So that's the sponsorship-only rent-a-center model. And let's go over to the marketing model. What is this? How does this work?
The marketing model, which is on the next slide, is pretty much exactly the same thing, except for instead of actually affiliating, are you on the next slide, Bernie?
Yes, sir.
Didn't show on my computer. Oh, wait, hold on.
Uh-oh, now your computer.
There it is. There it is. There was a little bit of lag. So in this case, there's essentially no sponsorship. Someone's gone to a regional center that has been successful in the past, and perhaps they have their own regional center. Or perhaps they don't need a regional center, but they need a little bit of help from someone that's been around the block. So they tap the experienced player in the industry and say, can you help us? And of course, pay a fee for that. Depending on how this is done, by the way, it could be illegal, because if a regional center is not supposed to be helping market and providing and raising funds for someone else because they're not a licensed broker-dealer, it could be illegal. But if the regional center is just helping to consult and getting paid a consulting fee that is, not tied to the operations and just kind of educating them and services like that, it could be just fine. But this is a slide basically that shows that as a regional center, once you become knowledgeable in EB-5 or various countries, you may be consulted as a industry expert and paid for that.
Sure, very, very helpful and kind of interesting, Michael. I have a question for you, because I had this happen to me yesterday. I was talking to a potential regional center investor, and this guy's actually in the United States and lawful status, blah, blah, blah. And he said to me, oh, Bernie, I've done all my due diligence. I have a project. I really like it. I called them. I wanted to invest, and they would not accept me. Repeat, they would not accept me as an investor because I was in the United States. They only wanted to accept investors from abroad. Jor, Michael, explain that to me. Why did they turn my client down? He's got the money, it's clean money, and they said, no, we will not touch you because you are applying from within the United States?
I'm glad you said that, and I hope that was one of our clients. And if not, then I commend them, this group. The reason they probably did that is because their offering, in part or in whole, relies on something called Reg S. Reg S is an exemption that allows you as an issuer, typically if you're raising money, you have to register, and that's expensive and it takes a long time. So most people look for an exemption. Reg S is one of those exemptions. It basically says if you conduct your offering entirely overseas, offshore, out of the U.S., and you're targeting only non-U.S. persons, then you're going to be exempt, at least from federal rules, not from state rules, but from federal rules. So what they did is they noticed that, hey, someone is here in the U.S. Doesn't matter if they're a temporary resident or not, they're resident. They're here in the U.S. So what they did is they said, well, if we take this person, it could jeopardize the availability of our exemption for the entire offering. And so they did the right thing in turning that investor away.
Yeah, no wonder it was a good project. They're following the rules. We as attorneys and advisors can only recommend that you strictly follow the rules. The SEC is not an agency you want to mess with. Homeland Security is not an agency you want to mess with. All of this has to be done by the rules. So let's jump over to what I believe is your last slide, which is now very much looks like spaghetti to me. Translated into English.
Yeah, so in this case, the Regional Center is sponsoring and marketing. This usually happens because the Regional Center is affiliated with the company. Someone has come up with a project, they need to indirect and induce jobs. They form the Regional Center for their own project, and therefore that Regional Center is both sponsoring their own deal and marketing their own deal. So typically there's no marketing fee. Theoretically, you could get a Regional Center that sponsors and markets for a third-person deal, and that does happen, but the same risks that apply with marketing a deal for someone else and taking fees on that, could apply, and there could be some risk there. But really, this is just to show that, hey, a Regional Center can just sponsor, just market, or sponsor and market.
Which is pretty much what we see. And, you've mentioned the word agents. People need to probably know that there are several major agents right now that handle most of the projects. I've heard talk of 500 registered agents in China, but really 5 or 6 really big ones that almost control the market. And both the regional centers, the investors, the lawyers, tend to work with the larger agencies. They know what they're doing. They have big staffs. And quite frankly, they're the folks who are able to source the funds, find the investors, which is, really the fuel that drives the whole program. But so that's where the overseas investors are found, as it were, and then we get into the various structures that we have here. So there's the biography for Jor Law. He really is knowledgeable. Top best lawyers, 2009, 2010, 2011. Hey, what happened, Jor? You didn't get nominated for 2012, or you just haven't updated your slide? I mean, you must have been a best lawyer for 2012, right?
No,
Tell me.
Super lawyer? No, I either got old or it didn't garner enough votes. I'll let you guys guess which one.
Well, we need to vote for you, Law, because you're not out there. I thought I was just making fun of you, but trust me, Jor knows his stuff. What's so important about this is you can find great securities lawyers, you can find great corporate lawyers, but the problem is they don't understand immigration, and they don't understand EB-5, and I have this all the time. Well, I've got my own corporate lawyer, I've got my own securities lawyers. I'm like, fine, go run up a $100,000 bill while these guys learn how to do it. The fact of the matter is you need to work with somebody who understands the program. I work with Jor. I recommend Michael. These are folks that I know. They know the rules. You have to know what you're doing in order to navigate this particular path. That's how we get hold of Jor. He gives out his direct line there, Jor at Homier Law. His partner, Michael, also very knowledgeable, corporate securities, business transactions. These are EB-5 gurus. And, I've always enjoyed working with them. So there we have it. There's young Jor Law. He's looks 20, but he's not. Michael Gibson, sorry, he looks better in real life. I took that off his website. And who's that old guy on the left-hand side? That's Bernie. It's actually an old picture. Beard's gone a little bit gray right now, but I think you're allowed to fake it because it's the internet. So, kind of faking a little bit. Anyway, try and get through some weak humor. We're almost out of time. I know you've got a lot of questions, so let's open this up to questions, see what we've got there. Okay, questions, there we go. Okay, start at the beginning. Well, somebody said thank you, that's nice. When do you have to start creating the jobs for EB-5? Before the filing 924 or at the time of I-526 or after you've released funds from escrow? The law basically says, this is the timing of job creation. The law basically says that you have hired or are in the process of hiring. You don't technically need to. Let's just take a direct investment. You go out there, you buy a Burger King, you put in $1 million, you've got to have 10 employees. When do you have to have those jobs? And the answer is pretty simple. You have to either have the jobs at the time you file. My ideal situation, by the way, the case that I just love is somebody puts in $1 million of clean money. We hire 10 employees through E-Verify other than family members, etc. Full-time jobs, 35 hours a week. We file the petition and bingo, let me tell you, that thing's going to get approved really quickly. If you just do a nice, simple, clean 10 employees, clean money, and you have it. But the regulations do say that you can be in the process. So maybe you've got 3 or 4 employees and your business plan, this is the point of the business plan. With the business plan, you show realistically that those jobs are going to be created. We spoke about this. What if there are delays and the jobs are not created? Are you in compliance? That's where it starts getting very, very complicated. So timing of jobs, either you have those jobs or you have a really good business plan to show those jobs are going to be created. That is not pie in the sky stuff. And then, of course, you're looking at your economic reports, your economic projections. How realistic are they? I hope I answered that question. I want to jump back to Michael Gibson because some of you may have forgotten that he's here, and he's gold when it comes to this. So, Michael, if you're there and if you can hear me, did Mr. Gibson state that as compared with individual I-526 versus regional center I-526, that I-526s for regional centers were not being adjudicated because USCIS wants to see how the business is using non-escrowed funds? Very good question. I thought I heard that as well, and I did not know that. Michael, can you comment a little bit more about whether or not 526s are being held up in the regional center context in this, based on this question?
Right. Well, we don't know for any certainty. I mean, getting clarity from USCIS, as everybody on the call will know, is at times very, very difficult. What we do is we speak to a number of attorneys. We work with over 100 law firms, and the feedback that we get from them is that in many of the limited partnerships, they're waiting for all of the limited partners 526 filings to be submitted, or at least a majority of them, to see if, in fact, the entity, the job-creating entity, has accomplished its goals as outlined in the business plan. And the reason I think that they're doing it is that, as you said, Bernie, the law states that that you must be in either creating the jobs or in the process of creating the jobs. We look at it at the time of the capital investment. So what some of the centers are saying that in the case that you mentioned earlier, if you're the first investor, Well, you really haven't had a chance to accomplish all of the goals as laid out in the business plan. So USCIS is saying, fine, as I believe, I mean, we don't know with any certainty, but I think that they're holding them until all of or most of the capital has been invested, and then the sufficient time has gone by, because what they don't want to have are the attorneys saying, well, my client was the first one, and I promise you the jobs will be created. Just trust me on that. I think CIS is taking more of a stance of, well, let's see once all the capital was invested, were the jobs actually created? Did you accomplish all of the goals as laid out in the business plan? And I think we have seen recently denials of 829s because, in fact, once the capital was invested, the jobs were not created. And I think so CIS is, again, this is my interpretation. It may be not correct, but my understanding based on conversation with attorneys is that they're waiting for the limited partner filings to be submitted so that they can see if the full investment of capital did produce the amount of jobs that they were claiming. And in some cases, I think they're saying the jobs were not created, and this is leading to denials.
Well, I'm going to go one step further and say I can confirm. I think it's pretty clear they are batching, at least by adjudicators. I'm not sure if they're holding adjudications in all cases, but they're certainly adjudicating by project, sort of going to the same officer. And we are also seeing this trend, as it were, where USCIS is trying to provide some sort of protection, I think, for investors by trying to weed out, I don't know if this is their role, but I think they're doing it, to weed out the more, let's say, risky, or I don't know if that's the right word, problematic programs. Let me just run through a couple other questions here. Can non-immigrant investors invest in the CRE in this case? I see no problem whatsoever, and maybe I'll leave that to Jor, make sure that I have this one right. Can non-immigrant investors invest in the CRE in this case? Yes, non-immigrants, people on student visas, people on H-1B visas. I don't see a problem there, U.S. citizens, but Jor, you tell me, this is your arena. Any problem with non-immigrant investors investing in the CRE in this case?
No, typically not. However, you do have to be careful that if you're doing a simultaneous project raise, that if the other investor that invests in that same exact offering, if they don't fall under the exemptions, you may need to find another exemption for it. I'll give you an example. Many offerings, especially the ones not done by our firm, rely exclusively on Reg S. And if Reg S, the offering exemption, says that the offering is conducted to non-U.S. persons offshore completely, in that beyond that, they can't even condition the U.S. market. So if they now go and they take a U.S. investor, then possibly the SEC could say, well, hey, this offering is supposed to be offshore to non-U.S. persons, but you have a U.S. person in there. There is a chance that the SEC could invalidate the entire offering. Now, the company would obviously argue and say, no, Reg S was everyone else. This person was its own deal. We didn't commingle the two. But unless they had separate documents and separate offering terms and really delineated the two, that might be an uphill battle.
Great. We have a question here about the issue with regard to Iranian clients and OFAC restrictions. The question, and I'll just read, a lot of banks who are holding escrow accounts don't accept wires from Iranian clients because of OFAC. Absolutely, yes. If certain, most actually Iranian banks are, subject to sanctions, you cannot transfer that money in. And, this was relatively easy to handle until recently because you just got an OFAC license. Problem is OFAC now isn't in the game of issuing these licenses, but you still have to comply with the law. So quite a problem. It's a little bit of a mess right now. We still want to, what a lot of regional centers are doing is, some of them at least, want to get an advisory opinion that we're in compliance or they're in compliance with OFAC sanctions and regulations. I'm not going to go into the specific method of answering this question. It's just too complex, quite frankly. We'll have to get deposited into a regular account. The bottom line is, and I just encourage anybody who's handling Iranian cases, you really need to go to the OFAC Treasury Department regs. They have a separate website page dealing with Iranian investors, not only Iranian, Syrian investors, other investors, because this program is impacted by sanctions and transfers from Iranian banks. Just really a no-no, and got to make sure it's not government funds. And if the money is earned outside of Iran, coming from Dubai, that's just a whole lot better. Or Germany, if the money was earned outside Iran. If the money was earned inside Iran, you may have sanctions issues. Let's move on to a couple other questions. Michael, this one would go to you. What are the characteristics, if any, of an attractive high-tech company as an investment as opposed to real estate? Wow, I don't give real estate advice, but everybody knows high-tech success rates a whole lot less than real estate where you've got equity. But gosh, Michael, can you give us a one-liner on that simple question? The EB-5 Regional Center Program specifically talks about startups, import-export, and energy-related projects. So let's assume that high-tech startup is something that they want to see happening. What are your words of wisdom on that, Mike?
Right. Well, the number one criteria that we look to when we make a risk evaluation on projects, we look at the stability of earnings. That has to be the creation of value, the predictability. The problem with startups is that you have neither. You don't have predictability. You don't have stability of earnings. In fact, you have typically in tech the opposite. You have huge R&D expenses and then a really uncertain cash flow, far from stable. So, and that's true of other industry sectors. We see that in commodities. And that could be commodities such as milk. We've seen a lot of issues with dairy, both good and bad. When we started, dairy projects were very popular in EB-5, and that was because they were making $8 to $10 positive margin on each hundredweight. Then it went down, and now the milk prices are back up. So energy sector, oil and gas is becoming popular now. The problem is the fluctuation of the underlying commodity plus the risk of extraction is too great. So anything that adds to stability of earnings or predictability of fair value, those would be projects that we would consider to be favorable for the EB-5 investor. And remember, the EB-5 investor is different from your private equity firms. If you had Sequoia or any Blackstone coming in, they may evaluate differently based on the probability of high return. But in EB-5, return is not really a factor. So what we need to look at are stability of earnings and the predictability of the asset to both create jobs and create value sufficient to exit. And in high tech, that's simply typically not the case.
I would actually disagree a little bit to that. I think that is true in today's world where most investors look for something safe and only something safe. But, being a startup investor myself and liking startups, I can also say that I've looked at startup deals that would make far safer, in my own opinion. And I'm not an investment advisor, but I am an investor myself. I look at startup deals that seem much larger, on the surface of them, it seems far safer to me than, in some of these large real estate deals. And I think that one day there will be a market where hopefully the investors will look at it and just say, well, heck, why am I investing just for the green card? Why don't I also get a return out of it? And in that case, I think the analysis has to change from are we only going to look at cash flow for return on investment to let's look at cash flow and operations to ensure that the jobs can be created. And if the jobs can be created, our client, the investor, already understands they may lose all their money, but so long as they get their green card and have a bet on the upside, they're okay with that. That day is not today, but I hope to see that in the future.
Joel, I'm going to side with Michael on this one. You know, if you're homeless living in Santa Monica 3 years from now, I'll know why. You went for the more risky stuff. Sorry, a little bit of kind of weak humor here. You know, this is one where both answers are right. It just really depends on what your focus is. And that actually leads to one of the questions we have here, which is there a restriction on what type of business qualifies for EB-5? Well, you know, if you were planning on buying that saloon in Vegas, you know, which engages in legal, which county is that in Nevada where, you know, prostitution is legal? And yeah, I don't know. I do not know. You know, that would be a legal commercial enterprise. You know, this is the federal government here. Basically, it has to be a legitimate legal commercial enterprise. So, you know, I don't know that I would be sort of investing in, you know, marijuana retail outlets in California or Oregon, even if they're legal. I don't think the feds are going to buy that. They're going to have a problem with that. But generally speaking, excuse my wry humor here, the bottom line is you can pretty much invest in everything, with the single most important point from my perspective being job creation. You know, is this investment going to create jobs? So I have another question that touches on this issue, which is, do 1099 employees count as jobs created? Now, 1099, my understanding of the government, is an independent contractor, not a labor lawyer. So if it's a 1099, then it's not an employee. I want to see, sorry, W-2s, W-4s, 941s. Those are my critical documents. I want to see payroll. I want to see payroll taxes. I want to see full-time jobs, not just jobs, full-time jobs, 35 hours a week. And no, you can't count the immediate family. So, folks, looking at the time, Michael Gibson's been very generous. He actually appeared here in person today. Jor, you know, this is the team. We've just finished part 4 in our series. I'm going to restart the clock and do redo the series. I thank you so much, everybody, for joining us. I hope you've enjoyed participating in our program today. Excuse my poor humor. Excuse my terrible handing of the forwarding and reverse of the slides, but, you know, lawyers and technology. And, you know, this is a great program, folks. Congress is going to expand it. Congress is going to continue it. Congress is going to support it. And it's very, very popular. It is red hot today. This is a program that works for immigrants, can work for regional centers and businesses as an excellent way of funding, and of course will help us perhaps reduce the terrible unemployment rate that we presently still have in the United States. I saw it just jumped up a little notch, 0.1. What are we at? 7.8, 7.9. Thank you very, very much, everybody, for joining us. And until next time, goodbye, and enjoy the rest of your day.